Border Patrol were ordered to parole people into the country, even if they had visible gang tattoos, and it was obvious they were a threat to the citizens of our country under the Biden administration. With that, I yield.
Thank you. Mr. Neguse, you're recognized.
Thank you, Madam Chair. Good morning. Welcome to our chairs and ranking members, and appreciate your testimony this morning. I want to start with maybe a fairly simple question. Just by way of context, as you all know, we started this hearing at 1 a.m., and I have been on a journey, I guess, or a quest for a very simple answer to what I think is a fairly simple question. But it's been proven elusive thus far, and the chair was unwilling to engage with me in a colloquy earlier on it. And really the question is, why was this hearing noticed for 1 a.m.? Why have we spent the past 5 hours debating this bill in the dead of night? Of course, I have a theory, and it's that this bill is indefensible and that House Republicans know that full well and decided that it would be in their interest to hold this hearing in the dead of night rather than in the daylight. But I wonder if my Republican colleagues, the chairman, have any thoughts on that front. Chairman Green, any observations you might offer as to, do you think it was prudent for this committee to convene in the middle of the night?
I don't have any opinion on when the committee is called. I'm an ER physician. I work day and night. I'm an ex-Army Ranger. I work day and night. It was 3 o'clock in the morning when we flew into Baghdad. Time doesn't matter to me.
Okay. How about this? How long have you been chairman of the Homeland Security Committee?
I'm in my second term.
Second term, how many years? Is that 3 years?
That would be 2+ this year, which I guess is January.
2+? Couple years?
2 years and 5 months.
You've held a lot of hearings?
We have, yeah.
Have you noticed any of them at 1 a.m.?
We've had some markups go past.
Not if they went past. Have you noticed any hearings at 1 a.m.?
I have not, no.
What time was the markup for your committee on this bill?
On this bill, I think 10 a.m.
10 a.m.
Yeah.
Interesting. Yeah. I'm pretty sure Chairman Jordan's markup was around 10 a.m. too, because I'm on his committee. The same goes for Chairman Westerman. The question I have is why the Rules Committee decided to deviate from the protocols that the chairs have apparently established, those who are testifying in front of our committee. Why this committee, the Speaker's Committee, decided to gavel in the middle of the night to take up this bill. It's an interesting question, and I've yet to get a good answer, but maybe the third panel will perhaps provide some clarity. Chairman Jordan?
I was going to say, when you got a great product, you want to get after it and get it passed.
Oh, is that right?
This thing cuts taxes, secures the border.
Let me talk to you a little bit about the product, Chairman Jordan. So I want to talk to you in particular about the contempt provision. So this is section 70302, a restriction on enforcement. You're familiar with this provision, right? Is that, you know the provision I'm talking about?
I'm waiting for you to explain it.
Okay. Well, you're testifying. I was going to ask you to explain it. So my understanding of the provision, you can tell me if I'm wrong or incorrect, is that this provision would bar any federal court from enforcing a contempt citation in a case in which an injunction or a temporary restraining order has been issued if security, that is to say money, has not been provided or ordered by the federal court in that particular case. Is that right?
That's right.
Okay.
I think that's existing law. I think
it's not existing law. I'll clarify. As you know, under the federal rules of civil procedure, it is discretionary as it relates to cases against the government, right? That's the whole reason for this provision. Otherwise, you wouldn't include this provision in the bill. This is meant, I'm asking a question. I don't know if, is that, is that right? Or am I
didn't hear the question. Say the question again.
What was that?
I didn't hear the question in there.
The question is whether or not this provision is as I stated it to be, that essentially it would preclude any federal court from enforcing a contempt citation in a case in which an injunction or a temporary restraining order has been issued if a security has not been provided.
That last clause is the key, if that security has not been put up, right?
Correct. And you're aware that the way in which you've written this provision, it would apply to any plaintiff in the United States. vis-a-vis a case against any entity within the federal government?
I can look at the drafting, but my understanding is it applies to the cases we're talking about with immigration cases.
Yeah, no, you're incorrect. So, yes.
What you're
cases,
saying are incorrect. I'm just saying
were,
how I believe it was written.
Okay,
you
well,
think it's written different.
Let me explain to you what this provision actually does.
I can't wait for your wisdom. Go right ahead.
Chairman Jordan, this provision would bar any plaintiff in the country from being able to obtain a contempt citation from a federal court in a case in which an injunction or a temporary restraining order has been issued if security has not been provided. It is not limited to the cases that you've identified. So let me give you an example. Let's say there's a citizen in Ohio, a constituent of yours, who believes that their private data has been improperly released, right, by the IRS, and they file a lawsuit against the IRS. If this becomes law, your provision, that individual would have to provide security, whatever security the court would deem reasonable. That is not something that has existed up until now. Do you understand that?
Got it.
Okay. So I'm trying to understand why you think that's in the best interests of the people that you represent in Ohio.
Judges were waiving this. Our understanding is this would prevent enforcement of a contempt order if security was not provided, if the security was not provided in accordance with the Federal Rules of Civil Procedure 6S. That's what we put in the legislation.
Yeah, this provision, so you're saying that essentially the way that you read this language is that it's not compelling the federal court to require security of a plaintiff.
That's a situation now the judge can waive it. We're saying it should compel the court to have the security there.
Correct. Yeah, we're saying the same thing.
Okay.
Let's go back to my core example, all right? We'll walk through it together here. A constituent in Ohio who believes that their information was improperly released by the IRS. I remember you've served on the Judiciary Committee for many years. Hold on.
We're talking about in the context of immigration cases.
This is all cases. This is not immigration cases. The plain language of this statute that you have written applies to every conceivable case brought in a federal court, period. IRS cases, patent cases, immigration cases. If you have a constituent that sues the ATF, this provision applies to them. This is the point. And you can visit with your lawyers and maybe they can provide you with the clarity, but it is unquestionably the case that this provision applies to every plaintiff.
Oh, okay. Yeah, that's
correct. I think we're on the same page now.
The judge can set the security at whatever level he wants. What's typically happened in these cases is he just waiving it. No one's putting it up, and they're getting this injunction that applies nationwide,
correct.
Which is the concern.
I hear you.
Are you okay with the nationwide injunction issued by one single federal judge?
We'll get to that part, Mr. Jordan. Let's complete the analysis on this piece, because to your point, as you said, this particular provision doesn't require a specific amount of security. It's essentially saying to the federal court it has to require some security. And my point is that this is a deep deviation from existing federal law. This has never been the case. We've never said to constituents, hold on, Mr. Jordan, I'll finish I'll give you a chance to respond. We've never said to American citizens and constituents that in order to vindicate their rights in federal court, they're going to be required to provide a security when their constitutional rights have been violated by their government. And I find it astounding. I'm not sure that many of your colleagues understand the full import of this. They will by the time this gets to the floor. I imagine there will be a lot of limited government advocates who will find deep reasons to be concerned about this type of provision, because as you could imagine, it will preclude folks from being able to vindicate their constitutional rights. Now, I would also say the way that you have written it, as you've noted, it's retroactive, right? So this applies to any...
I just want to say the situation we're trying to address is what's been happening around the country.
You didn't write it that way.
As you know, a single federal judge gets cases brought to the judge. They waive the security and then issue a decision that applies nationwide to all immigrants who are in that situation.
Why didn't you put nationwide in this language?
Well, we can look at the language. I mean,
it's 6 a.m. You're voting on this thing in like 10 hours. What are we talking about? We've had weeks. You could have put nationwide in here. That's not what it says. This applies to every one of America's 330
I mean,
million
again,
citizens.
the judge has discretion on what that amount can be.
Sure. So a judge could say, you know what?
And judges are right now waiving it, and that was the concern we had.
Sure. And I think a judge.
And you don't think that's a problem? Even Supreme Court Justice Kagan has said there's a problem with these nationwide injunctions being issued from one single federal judge. That's what we're trying to get at.
Okay. The Supreme Court's considering that question right now. I will just conclude here.
Well, all I'm saying is,
let me conclude my statement,
even more liberal justices have said this is a problem.
I understand.
We've actually passed standalone legislation.
Mr. Neguse,
He's had every
please
opportunity.
let Mr. Jordan speak, and then he will let
I
you
will-
speak.
I'll finish my question and then he can answer.
Okay,
Or I'll
but
just
you're
make
not asking a question.
Okay, sure.
You're asserting a statement.
Madam Chair, Mr. Neguse controls the time.
Yes, sir.
And so.
But I'm trying to ask him to ask a question and then let Mr. Jordan answer.
I will conclude my statement and then ask a question of Mr. Jordan, since he, I don't think, wants to engage in this constructive dialogue to try to actually address the purported problem that he is trying to solve. So I will simply finish the hypothetical that I offered. Any constituent in Ohio who believes that their private data has been disclosed improperly by the IRS, any citizen of Ohio or Colorado, for that matter, who believes that their constitutional rights have been violated in some way, if this becomes law, they would be required to pay the court money in an amount that the court deems necessary to cover the costs of the potential damage in order to proceed in federal court. That has never been the law of the land in our country, and I cannot believe that Freedom Caucus, so-called Freedom Caucus members, would support that kind of principle. Secondly, the way that this is written, as you noted, Chairman Jordan, yes, this would apply to the 93, 94 different injunctions that have been issued against the Trump administration. It would also apply to any existing injunction that is in effect today. I don't know what that number is. 1,000, 10,000 desegregation injunctions that are still operating today in different federal courts in the country. A variety of different litigation that's pending in different courts across the country that would be implicated by this provision. So I don't think that ultimately it's going to survive the bird bath in the Senate, because it's clearly changing policy. I also think it's patently unconstitutional. There's no world in which the Supreme Court would ever deem this, and we could go through the Supreme Court precedent that establishes that. But I just also would encourage you to take perhaps legal counsel on the Judiciary Committee can take a deeper look at this paragraph, because as it's written now, it is deeply problematic for civil liberties in our country. Ranking Member Raskin, I can see, has been jumping at the opportunity to.
Well, I mean, I think you did a pretty masterful job of addressing it, Mr. Neguse, but I would add just two things. One, it's worse than you say, because it doesn't just apply to cases against the government, it applies to private cases as well. There's nothing in the language here that would exempt a case between two private parties, two commercial parties. And so, but your final point, I think, is the key one. It's blatantly unconstitutional. It's because the power to hold someone in contempt for a court is an inherent judicial power and has always been deemed to say that. They don't need to wait on Congress to give them the power to hold someone in criminal or civil contempt for refusing compliance with a court order, any more than we do when we at least used to, engage in the inherent powers of contempt that Congress has against people. We don't need to wait for another branch of government to give us that power. So it is unconstitutional. It's ridiculously broad, and it's a very ham-handed approach to what their real issue is. They don't like the fact that Judge Boasberg, who was a Bush appointee when he first got on the bench, he was Justice, which he was one of the justices' roommates at Yale, I think. Well, anyway,
Kavanaugh.
he's a
Kavanaugh.
Yeah, Kavanaugh. He was Justice Kavanaugh's roommate. He was a pillar of the conservative bar, right? Well, they don't like his opinion because he said, turn the planes around and give this guy due process. And then they laughed at him. I mean, the president of El Salvador was tweeting, oopsie, we made a mistake, like he was mocking the judge. And this is a judge who doesn't fool around. He's a stickler for the rule of law. And so he said, I think there's probable cause to believe that whoever in the administration disregarded my authority and didn't turn the planes around and didn't guarantee due process is in contempt of court. And he said, and I'm going to get to the bottom of it, and I don't even need to rely on the marshals of that report to the attorney general. I can appoint my own people to go get them, and I can also use civil contempt and slap fines and liens on people. So this whole provision is really targeted at him and other judges who are saying a judicial order is not something that anybody, including the President of the United States or people who report to him, can defy with impunity, because under Article 6 of the Constitution, we have a supreme constitution. We don't have a supreme dictator in America. The Constitution is what governs us all, and it's emphatically the province and the duty of the courts to say what the Constitution means.
I agree, Ranking Member Raskin. I think you articulated it well, and maybe my hypotheticals earlier were a bit too obtuse. I'll give a tangible example. There was a case a few years ago, Ranking Member Raskin, you're probably familiar with this, Missouri versus Biden, right? This is a case, Chair Jordan, I know you're familiar with this case as well, because you led an amicus brief in this case, right? This was a case initiated by the Missouri Attorney General against the Biden administration for their perception that the Biden administration was engaged in censorship of conservative voices on social media. And Chair Jordan, you led an amicus brief on behalf of judiciary Republicans in that case. A permanent injunction was issued in that case against the Biden administration. The state of Missouri was successful. Chair Jordan, do you know if a security was issued in that case?
Don't know. It's up to the judge.
It was not. There was no security in that
It's
case.
up to the judge.
Well, no, this is the point. There was no security in that case because under existing rules, it is not the case under Rule 65, subsection C, generally speaking, as a matter of just general practice, security is not issued, or rather required, in cases involving the government. And that is the point. If this provision became law...
It could be required, the judge waives it. That's what happens.
If this provision became law, two things would happen. Two things. One, the permanent injunction that I suspect remains in place, the Biden administration, that's gone. You can't enforce it anymore because of this provision. And then secondly, as we've probably belabored here at this point, it would make it very difficult, potentially, for similar types of lawsuits to be initiated in the future by prospective plaintiffs against the federal government if they feel as though their constitutional rights are at risk. So anyway, I will close there, but I think it's a deeply problematic provision. It ought to be removed. And I yield back.
Thank you, Mr. Neguse. Do you feel properly instructed now?
Fine. I'm fine.
You're properly
Yes.
instructed. Thank you. Mr. Griffith, do you have any questions or comments you'd like to make?
Yes, Madam Chair, I do.
Recognize.
First, I want to respond to Mr. Neguse's question of why we started this meeting at 1 o'clock in the morning. And there may be different opinions, but when the chair lady was out and I was sitting in the chair in our meeting on Monday, I said to members of the other side of the aisle, I don't remember who was in the room or not, but there were Democrats in the room. I said, look, the reason we want to start is that you all will have a lot to say. We want you to have time to say it in. And if we don't start early and we want to get this done, we have to start early. And I said, now, if y'all want to put a restriction on the time, we could start later in the morning, perhaps. And then there was no response directly to that, but there was a response that something along the lines of, we're glad you're not going to try to limit our time as has happened in some other committees. So, I mean, we could have worked out a different time, but and it's true that we have set the clock as to when we want to try to get this bill across if we have the votes to do so. And that's within the majority's prerogative. But the reason we're meeting at 1 a.m., Madam Chair, in my opinion, based on that discussion, was that the Democrats did not want to restrict themselves to 2 hours or 3 hours of discussion on this. We've already been at it over 6 hours, and that's appropriate. But it just strikes me as just one of those oddities in life. You complain that we start at 1 o'clock in the morning when what we're trying to do is to accommodate the ability for members of this committee on the other side of the aisle to speak their mind. And now, hang on, I get to say my piece. If that was not the case, and if people were willing to say each panel is only going to have an hour, we could have started later. And that was not the case. And I respect that, but I just don't want to be whipsawed by saying we all started in the middle of the night for some other reason. The reason was so there'd be plenty of time so we can get through this thing, let everybody have their chance to say their piece, and then we can move forward. So with that said, I will ask this question of Mr. Jordan. Mr. Jordan, is there anything that you didn't have an opportunity to say in the discussion that's occurred thus far that you had great desire to say?
Well, I was just going to say, I think the overall legislation is good legislation. Cuts taxes, secures the border, requires work, and gives moms and dads the ability to pick the school that they think their kids are going to get the best education. Those are 4 fundamental principles that I think vast majority of Americans agree with. That's why I think the bill is so good overall. And I think what we were able to do in our committee, particularly proud of, and that the fact that we were charged with just spending, allocating resources to keep the border secure, but also we're able to bring in revenue to help help offset the cost to secure to keep our border secure.
All right. I thank the gentleman. I have no additional questions. You yield back.
If you yield